Hello and welcome to another EPM webinar on how to manage the issues arising from the coronavirus crisis. I'm Richard Smith, one of the employment law experts with the EPM, and today we're going to be going through a range of topical issues that have been generated by customers raising questions with us. In this webinar, we're going to be covering a number of really interesting questions that have been raised by our customers over recent weeks. Double bubble trouble. What to do in those circumstances where you have a member of staff who's possibly working in more than one setting with a consequent risk to health and safety. Post-holiday quarantine. How to deal with situations where a member of staff is proposing to take holiday abroad, which may result in them being unable to attend work due to the need to quarantine in line with government guidance. BAME risk assessments. Is there an obligation upon employers in the light of all the concerns raised recently about the impact on BAME people of COVID-19 to undertake separate risk assessments and to take particular measures to protect those people from harm? Disciplinary capability, restructure and other employment procedures. Is it open to the employer now to recommence those processes that may have stalled due to the lockdown? And also, with particular support from our partner company, Southalls, what control measures should you be putting into place to manage movement around schools, particularly in those schools where there might be limitations upon your physical environment, causing difficulties in maintaining social distancing? We face several questions from customers whether having what's called double bubble trouble. This is the situation where an employee works part-time in one school, but also has employment perhaps at another school, meaning that they work within more than one bubble, which some schools think defeats the object of the bubble concept in the first instance. How do you deal with this? A number of customers have raised questions about employees who are working both in their setting, but perhaps in another setting, and in consequence are engaging with more than one bubble at any given time. This has been a great concern because, of course, we're trying to preclude people from working with multiple groups of children, and by working elsewhere, this really flies in the face of what the school is often trying to achieve. The start point is that the school has to make their own risk assessment as to whether or not this is a suitable and safe method of working. If they conclude that it is, then that's a matter for them to determine in line with their health and safety advice. Health and safety advice on these matters is available from our partner company, Southalls, if required. If, however, the school conclude that this is not a safe way to work and that it does breach the concept of the bubble that they're trying to implement, then they may want to talk to the employee, they may want to talk to the other school and try and find an accommodation that means that the employee can continue with one or other employer in a way that is deemed to be safe. However, if this is not possible and the employee insists that they're going to continue to work elsewhere, then essentially what they're doing is to say that they are not ready, willing and able to undertake their duties under their contract in a way which is safe, and the employer can, in those circumstances, say, you must come back to work with us, you must not do something that makes this impossible. If you fail to do that, you're in breach of your contract of employment, and therefore we are not going to pay you for that period of time, and indeed it might even lead to further proceedings if the employee persists in that view. Of course we're going to seek to discourage that as an outcome, but these are possible options for the employer to insist upon the employee's return to their setting, and certainly not to continue paying somebody for not being able to work when they're unable to work for reasons that are within their control. The imposition of quarantine on people returning from abroad for a 2-week period by the government has created a number of employment issues. Some employees plan to take holidays in any event and are then saying, well, when I return to work, when I return to the UK, in fact, I won't be able to work for a 14-day period. What does the employer have to do in those cases? The government's position on quarantine has been developing, and as it stands, employees who travel abroad will, in most instances, be required to quarantine at home for a 2-week period after their return from an overseas trip. This is causing problems where that's going to eat into the time when employees are meant to be at work. The question that's being raised is, do we have to allow people that time off? What are the options that we have in these cases? Can we insist that the employee takes that as either holiday leave or unpaid leave, or that we take action? Well, essentially the decision is for the employer. There is no right for the employee to insist upon these periods of leave. There is no right to say, well, I've got to quarantine, so I'm not coming into work and you still have to pay me. The employer can say to the employee, if you go on leave, you must return the day after that leave ends. And if by going abroad you make it impossible to return to work, then we're entitled to say that you have failed to honour the terms of your contract and therefore we're not going to pay you, or indeed in some cases to take disciplinary action. There's of course a range of options this employer is going to take before they get to that point. They may decide that there is a difference between an employee who has knowingly booked holiday in the light of the government's guidance that quarantine is going to be required, and somebody who'd perhaps paid for a holiday many months ago and had no reason to believe that it wouldn't proceed. Employers might be more favourably disposed to the latter case. There could be some situations where the employee's perfectly capable of working from home for a short period of time and there are no issues in consequence, and the employer is willing to tolerate that. But there may be other cases, of course, where the employer is saying, well, this is a classroom-based member of staff. We need all the classroom members of staff to be able to teach or to support students, and therefore this is just intolerable that the person is not going to be returning to work, in which cases you can take that view of saying no work, no pay, no work, possibility of disciplinary action. There's lots of issues around the position of BAME staff and people in relation to the COVID crisis. This has led to some organisations and commentators suggesting that there should be separate risk assessments undertaken for BAME staff and different measures put in place to support them. There's a high level of attention being applied to the position of BAME people in relation to the COVID crisis. It seems that there is a disproportionate impact for such people, both in terms of the likelihood of infection and the possible outcomes of infection should they contract COVID. The suggestion is that in consequence of this, there ought to be a separate risk assessment for people with BAME backgrounds, and beyond that, that there may be special measures to be taken, for example, by requiring such staff to work from home until there is a vaccine available or until matters have changed in some other respect. This is a concern because that will lead employers down a path that means that they are making employment decisions based upon the membership of an ethnic group, and those people who don't belong to that ethnic group may have similar concerns in relation to their own position that the school is unable to address. We think it's possible that there could be an Equalities Act breach by taking a view that says we will take separate decisions and make separate arrangements for people based upon their ethnic background. Beyond that, the advice from our health and safety partner Southalls is that actually this approach is wrong from a health and safety perspective, because what we should be doing is to ensure that the workplace is safe for all staff, not just for some staff. And it's necessary, therefore, to put into place sufficient protective measures to ensure that any employee attending work is safe. If you have individual risk factors pertaining to a particular person, that they are identified and that appropriate action is taken in those cases where there's a particular risk. So, for example, it could be that you say this employee has got a particular medical condition that means that we ought to take particular decisions in relation to them. It could be that we say that the social distancing measures that we put into place have to be sufficient to protect all employees, whatever their background. And we know that aside from BAME staff being more at risk of COVID and the consequences of COVID, this also applies to other protected characteristics. For example, male workers are more likely to experience harm than female workers, Older workers are more likely to experience harm than younger workers. Workers with disabilities are more likely to experience harm than those without disabilities. So it would be inappropriate, we think, to highlight one protected characteristic and to make a decision in terms of how we deal with this situation. Based upon that, we need to look at the position of all employees and make sure that it's safe for all employees to return to work. Where customers were undertaking employment processes such as restructures, disciplinaries, grievances, capability prior to lockdown, it has proven difficult to progress those whilst employees have largely not been in the workplace and trade union representatives have also been largely absent, and pressure has been placed upon employers not to do so. Now the question is being raised, as people come back to the workplace, can we restart those processes? The short answer to this question is yes. Indeed, there was no reason in principle why these processes couldn't continue during the period of lockdown, although in practice we ran into many practical and logistical issues in so doing. For example, ensuring that employees and representatives could confer during a meeting, or enabling meaningful consultations when trade unions couldn't easily talk to employees about a restructure. So many issues have been paused. They can now be restarted, and there's no reason not to deal with those cases that were in existence either before the lockdown started or indeed that have arisen since. The employer must, however, manage cases fairly. There is no ability to say, because of lockdown, we have to move more quickly with the consultation process, for example. We have to deal with proper investigations in disciplinary and capability cases, and there may be a case for moderating the approach that we take in certain instances. For example, in capability cases, it may prove really difficult to effectively monitor the work of an employee during the period of blended learning. Perhaps while they're still doing online learning for many students, lesson observations might become rather difficult. So it could be that the outcome of some processes also needs to be adjusted to reflect for the fact that we are in a very different environment. However, absolutely the answer has to be yes, you can continue with those processes, and provided you do make the appropriate adjustments to reflect the difficulties incumbent in the current situation, absolutely no reason why these can't continue in the normal way. In many schools, there are limitations upon the physical premises that people operate within. A question that many customers have raised is this: how should we control that risk, where groups might need to move past one another, particularly in sites where perhaps there is only one set of stairs? EPM, we've worked closely with our partner company Southalls to understand the requirements of schools in these circumstances. The guidance from the UK government is that where schools can keep children and young people in small groups 2 metres away from each other, they should do so. They should also indicate, however, that brief transitory contact, such as passing in a corridor, is considered to be low risk. The way to achieve this will vary from school to school, but our recommendations include staggering of break, lunch, arrival and departure times, minimising classroom changes during the day, the holding of assemblies online or within the classroom rather than as a whole school group, and where possible the introduction of good practices such as space markings, along with communications to all staff and students that they should keep left in corridors and staircases. If you do have further health and safety queries, please don't hesitate to contact our sister company Southalls, who will be able to assist you with these questions. We hope this has been a really useful and informative webinar, and you'll keep coming back to look at further webinars as we publish them. There's lots of support available from EPM. Our website contains a wealth of useful information, and we're constantly updating our frequently asked questions to deal with the latest issues that are coming through. We provide full support services to our customers who need assistance with all the HR ramifications of this situation. And we're also providing for non-customers a free helpline that enables you to get access to our skilled advisors so that you know how to deal with these cases and you can understand the latest thinking around what schools are doing and best practice in managing a return to work. Thanks very much for listening. Talk to you again.